Last week, a jury in Los Angeles did something that has never been done before. They found Meta, the company behind Instagram, as well as Google, the company behind YouTube, liable for designing their platforms to be addictive to children. A 20-year-old individual who started using YouTube at age 6 and Instagram at age 9 just won a total of $6 million in damages, and this case could change the internet, specifically social media as we know it. I'm going to break down exactly what happened, why it legally matters, and what it could mean for creators, parents, and anyone who uses social media. Let's get into it. In March of this year, 2026, a jury in Los Angeles County Superior Court ruled against Meta and Google in a case called K.G.M v. Meta. The plaintiff is identified by her initials K.G.M. She's now 20 years old and from Chico, California. According to her testimony, she started using YouTube when she was 6 years old and Instagram when she was 9 years old. She told the court that her early and constant use of these platforms triggered an addiction that made her depression and mental health struggles significantly worse. The jury, 5 men and 7 women, deliberated for more than 40 hours over 9 days. They found that both Meta and YouTube were negligent in the design and operations of their platforms, and that this was a substantial factor in causing harm to the individual, the plaintiff. They awarded $3 million in compensatory damages and an additional $3 million in punitive damages for a total of $6 million. Meta was found 70% responsible, while Google was found 30% responsible. Now, $6 million sounds like a lot of money, but for companies worth trillions of dollars like Meta and Google, it's basically nothing financially. So why is this case such a big deal? Because of what the jury actually decided and what it means for every case that comes after it. To understand why this verdict is historic, you need to understand a law called Section 230 of the Communications Decency Act. For decades, Section 230 has been the shield that protects social media companies and platforms from being held responsible for what users post on their platforms. If someone posts something harmful on Instagram, Section 230 essentially says that's on the user, not on Meta. It's the reason social media companies have been almost untouchable in court to be held liable. But here's what made this case different. The plaintiff's lawyers didn't go after the content on the platforms. They went after the design of the platforms themselves. They argued that Instagram and YouTube are defective products, not because of what people post on them, but because of how the platforms themselves are built. The autoplay features, the infinite scroll, the algorithmic recommendations, the notification systems, all of it, they argued, was deliberately engineered to be addictive, especially to young users. And that's the legal move that got around Section 230 to hold these parties responsible. Because Section 230 protects platforms from liability over content. It doesn't protect them from liability over product design. By framing this as a product liability case, similar to how you'd sue a car manufacturer for a defective vehicle, the plaintiff's attorneys were able to put the platform's own engineering choices on trial. This is the first time a jury has treated a social media platform as a defective product. That's the precedent here. And that's why the dollar amount almost doesn't matter. What matters is that the jury said, yes, these platforms can be held liable for how they are designed. And this case didn't happen in isolation. The day before this verdict came down in Los Angeles, a completely separate jury in New Mexico ordered Meta to pay $375 million in civil penalties for failing to protect children from predators on Instagram and Facebook. That jury found Meta had violated New Mexico's consumer protection laws by misleading the public about the safety of the platform. So, in the span of 48 hours, Meta got hit with two major verdicts in two different states over two different types of harm to children. And that's really just the beginning. There are over 2,000 similar lawsuits currently pending against social media companies across the United States. Legal experts are comparing this to the big tobacco litigation of the 1990s, which eventually resulted in a $206 billion settlement and fundamentally changed how the tobacco industry operated. TikTok and Snapchat were originally named as defendants in the K.G.M case, but both settled before the trial began. The settlement amounts were not disclosed, so they're not off the hook for liability. They just chose to pay rather than face a jury. And the jury's finding of malice, oppression, or fraud in the punitive damages phase is particularly significant. Punitive damages are meant to punish. That language tells future courts and future juries that this isn't just negligence. The jury is effectively saying these companies knowingly designed harmful products and didn't care. Both companies have said they plan to appeal. Meta released a statement saying that teen mental health is complex and can't be linked to a single app. Google's spokesperson said the verdict misrepresents YouTube, arguing that it's a streaming platform, not a social media site. And honestly, those aren't unreasonable positions. Mental health is complex. There are usually multiple contributing factors. In fact, during the trial, Meta's lawyers argued that other factors in the individual's life, including her family environment, were the real cause of her mental health struggles. The defense tried to show that she turned to social media as a coping mechanism for problems that already existed, not that social media caused the problems. But the jury weighed both sides and decided that regardless of other factors, the platform's design was a substantial contributing factor. And the substantial factor standard is important. It doesn't mean the only factor or even the primary factor. It means it meaningfully contributed to the harm. That's a lower bar than most people realize. In this case, the jury said Meta and Google cleared the bar of being a substantial factor that contributed to mental health issues. So what does this mean if you're a creator, a user, or a parent? It means a few things. For creators, this doesn't directly change how you make content today, but it signals that the platforms you build your businesses on could be forced to change how they operate. If courts keep finding that algorithmic recommendations and engagement features are defective, companies may have to redesign and reconfigure those systems, especially as it pertains to younger users. That could affect reach, discoverability, and how content gets served. For parents, this verdict validates what a lot of parents have been saying for years, that these platforms aren't safe for kids in their current form. It doesn't change the platform overnight, but it adds legal and financial pressure that could eventually force meaningful safety changes to occur within the platforms themselves. And for everyone, this case is about accountability. For years, social media companies have argued that they're just platforms, not publishers, and that they can't be held responsible for what happens on their platforms, on their products. This verdict says otherwise. It says that if you design a product to be addictive and you know that it's harming people, you can be held liable for that design choice. And that is a fundamental shift in legal thinking that is coming from this case. Now, I want to be clear about what this does not mean. This is one verdict. It will be appealed. It could be overturned. Legal experts have said this is one step in a much longer process, and we shouldn't expect to see major platform changes immediately. But the door is now open in a way that it wasn't open before. Here's my take. As someone studying intellectual property, entertainment, and tech law, I think this case was legally creative and strategically forward-thinking. The decision to frame this as a product design case, product liability case, instead of a content case was the move that changed everything. It found the gap in Section 230 and drove straight to it. Whether you agree with the verdict or not, the legal strategy here is something to be studied and likely will be studied for years. As a creator who builds on these platforms, I have complicated feelings. I need these algorithms to exist. We all do in order for our content to reach our audience. If platforms fundamentally change how they surface content, it could make it harder for small creators to grow. But I also don't think that both of those things can be true at the same time. And who got tired of gatekeepers deciding who gets a shot, which is literally why I started this channel, I think there is something important about a system that holds powerful companies accountable when their products do cause harm. That is what the legal system is supposed to do. This story is far from over. I'll be watching the appeals and the next trials as they happen. If you want to stay informed on how the law is shaping the platforms we all use, subscribe. I cover topics like this every week. That's the breakdown. Instagram and YouTube were just found liable for designing addictive platforms that harmed a young user. $6 million in damages, over 2,000 more lawsuits waiting in the wings, and a legal precedent that could reshape how social media companies operate. What do you think? Was this the right verdict? Drop your take in the comments. And if you know someone who needs to understand what's happening with social media and the law right now, share this video. I'm Stevie. This is Girl Code of Law. I'll see you next week.